सब्सक्राइब कीजिए हमारे यूट्यूब चैनल शॉर्ट हैंड डिक्टेशन लीगल मैटर्स को और दबाइए इस बेल को ताकि आपको मिल सके हमारा वीडियो सबसे पहले और यह बिल्कुल फ्री है। Ready, start. Insofar as the present controversy is concerned, it would now be necessary for the court to formulate the basic principles which have emerged on the subject. The Police Act 1861 and the rules framed under it constitute a self-contained code, and by virtue of the provisions of Article 313 of the Constitution, the Act and the rules continue to remain in force. Under Article 313 of the Constitution, rules and government orders referable to a specific source of power under the Police Act 1861, such as Section 2, or as the case may be, Section 46 2C, would continue to hold the field and would not be abrogated merely by the exercise of the general rule-making power conferred by the proviso to Article 309 of the Constitution. Under the proviso to Article 309, rules regulating the recruitment and conditions of service of persons appointed to services and posts in connection with the affairs of the Union and of the states can be made until a provision in that behalf is made by or under legislative enactment of the appropriate legislature. Any rule so made will have effect subject to the provisions of the Act when there is a specific provision. Unless there is a specific any rule or order relating to the determination of the conditions of service of the police force can be made only under the provisions of the Police Act or by the legislation enacted by the state legislature governing the service conditions of the police force. 542. Repeal of the existing law. The question of an implied repeal would not arise. The rules framed under the proviso to Article 309 of the Constitution would apply, generally speaking, to government servants appointed in connection with the affairs of the Union or, as the case may be, the states, but the police force would be governed by the provisions of the Police Act 1861 and by the rules and administrative determinations referable to a specific source of power under the Police Act 1861. Under Section 2 of the Police Act 1861, the state government has been vested with power to determine the pay and all other conditions of service of members of the subordinate ranks of the police force. The determination within the meaning of Section 2 may be both by means of the exercise of the rule-making power as well as by an administrative direction. The Police Act 1861 being a complete code as enunciated by the Constitution Bench of the Supreme Court, it occupies the entire field of the determination of service conditions. The power to determine all the conditions of service of members of the subordinate ranks of the police force is vested with the state government. The state government has the rule making power under section 46 2c to carry out the purposes of the act by framing rules. Once a self-contained code in the form of the Police Act has been enacted by the legislature and its continuance after the adoption of the Constitution is ensured by Article 313 and Article 372 of the Constitution, the field relating to recruitment and conditions of service of members of the police force in the state stands occupied by the legislature. Stop.